The Supreme Court is set to hear oral arguments in a case that could determine the extent of First Amendment rights for roughly 50 million students nationwide. The case stems from a lawsuit filed by the parents of a high school cheerleader punished by her school for a profanity-laced series of Snapchat posts in 2017. Brandy Levy, who was 14 at the time, sent a picture on Snapchat to roughly 250 friends after failing to make the varsity cheer team. A fellow cheerleader took a screenshot of the messages, which are generally deleted after 24 hours. She showed them to one of the coaches, resulting in Levy's temporary removal from the junior team. The Supreme Court's decision could have tremendous implications on the authority school districts have over students while they are away from the classroom. Joining me now is Justin Driver. He is a professor of law at Yale Law School and author of The Schoolhouse Gate: Public Education, the Supreme Court, and the Battle for the American Mind. Welcome, Justin. Great to have you with us. So first off, explain why this is such a monumental case. How did we get here? Because we know, a free speech case involving students and school is very different than a free speech case involving the average American, correct?
Yeah, that's right. It's a really important case because the Supreme Court has handed down a series of decisions that regulate student speech while they are in school. But this case is incredibly consequential because this goes to what students can say outside of school. Brandy Levy was at a convenience store on a Saturday, very far removed from school, and expressed her frustration with failing to make the team in a way that is quite common among adolescents all around the country. And to permit the school to punish her in the fashion that they did would really send a chilling message to students about what they can say.
Well, we have seen other cases of similar things happen, right? When kids post really regrettable things on social media that end up resulting in them getting acceptance to a school taken away, or other such punishments, correct? Would those cases fall into this bucket as well?
Yeah, here we're thinking about elementary and secondary schools, which have their own particular, set of constitutional rules. And I would regard the sort of admissions standards as being a different phenomenon, just a sort of different kettle of fish, where the universities have just much greater authority on this front to prevent somebody from coming who's been accepted than does the government in the form of the public school to sort of regulate students in this fashion.
Right. Of course, it gets back to the fact that social media has just created, has changed the landscape so tremendously and created this sort of gray area where school life sort of stops and real life begins, but it's unclear. So what could the outcome of this case mean for students' First Amendment rights?
It's a really important
off campus,
question.
Wherever you want to call off campus.
Yeah, it's a really important question, and it's something that the justices were struggling with today as they thought about the prevalence of social media. And if one listened closely, you could hear them suggesting that just maybe there should be some rules that apply to social media posts that would be different than what one says to a friend at a party on a Saturday night. And so I suspect that the ruling will be a very narrow one. I would be surprised if the court said that it would be permissible to punish Brandy Levy for this statement. But the devil is in the details here.
Sure. And of course, as you point out, this incident took place off campus and over the weekend. Additionally, Levy's lawyers are arguing that the client didn't harass or threaten anyone in her Snapchat messages, and therefore she should not have been punished in this manner. What about cases where you see students being punished in a similar vein for Snapchat messages that do bully or target other kids? Would that also fall under the jurisdiction of a school being able to punish that student?
Yeah, that's a really important question, and the ACLU's lawyer was quite clear that if there's speech that involves harassment or bullying or sort of threats of violence or intimidation, that there are mechanisms that are consistent with the First Amendment that would allow, officials to punish individuals for that conduct. But the question here is whether the rule that comes from a case called Tinker versus Des Moines from the 1960s, which says that if there's a reasonable fear of a substantial disruption, then it's permissible to punish students for speech. That's not a very protective measure as to whether that should apply to off-campus speech, and that is a sort of different kettle of fish.
And the idea that it will result in substantial disruption, it's like who gets to determine what that is and what that means, correct?
Yeah, that's right. And the Supreme Court has not handed down very clear guidance. It can be understood to read a heckler's veto into the First Amendment doctrine. That means that particularly sensitive listeners can, if they object vociferously enough, silence otherwise legitimate speech. They can say, "What your T-shirt's really making me mad," even if the T-shirt is not on itself objectionable. And that gives school authorities a great deal of authority to punish otherwise legitimate speech. And my concern is that school officials ought not receive that same broad grant of authority in instances where people are far beyond the schoolhouse gate, not engaging in, say, a Zoom classroom and remote learning and things of that nature. The school setting can exist in places that are not in school itself, as we all know very well today, but there are some non-school settings, and those are quite important to protect for students' constitutional rights.
So in this case, which is so significant, as you pointed out, is the court likely to write a decision that will not only answer this particular situation of this particular student, but speak to some of the other, eventualities that you outlined, the other ways that this decision could be read in different situations?
Yeah, that's something, again, that the Supreme Court really was struggling with today. There was some talk among some of the justices that a narrow ruling would be preferable, just sort of decide this case. On the other hand, lower courts and school administrators have really been wrestling with what to do with this pervasive issue of off-campus speech. And so many of them surely would want much greater guidance as to when it's permissible to punish students for off-campus speech. And, this is a relatively unusual case because we're dealing with an extracurricular activity rather than, say, a student who is being suspended from school, which would be, many people would suspect, a more aggressive action. So we should expect a decision from the Supreme Court at the end of June, and we'll have some clarity on this matter.
A lot of school administrators watching this decision very closely. Professor Justin Driver of Yale Law School, thanks so much for joining us.
Thanks for having me.